Let's do it. I've got the AI up and running, giving me a research plan for the evening. I'm Know Nothing attorney. I know nothing, so you can too. Because it's only in embracing that we know nothing that we can actually learn anything. And that's what we're setting out to do. We're going to learn. That's what we do every night. We learn by researching, we learn by debating, we learn by conversing. One of these days, we're going to learn by talking to people who know some shit. It hasn't been any of you so far. Hi, Lasagna. Hi, Lasagna. Lasagna is a good girl. It's true. Sorry. She's better than your dog. Okay, so tonight we're doing debate topic 3 to prep. Debate topic 3 is the military owes allegiance to the Constitution, not the president, not to the president. Should be a very easy one to prep, but we gotta do it anyway. We gotta be ready. Last night's research was fun. I love researching religious liberty. Okay. Research plan. Oh, I might as well discuss the title of tonight's stream, because what the fuck? I'll probably mention it later when there's actually some people engaging. But today, Trump declared the F drug to be a WMD, a weapon of mass destruction. And all I have to say to this, in addition to the insane Rob Reiner self-implosion from Trump, what the fuck, Trump supporters? Where are y'all at? Can we get you guys to come back from reality? Come back to reality? Because if it's not enough to just redefine what DEI is, to just redefine what CRT is, to redefine how gender transition works for kids, if it's not enough to say Haitian immigrants are eating dogs and cats, if it's not enough to say that trans kids are using litter boxes in schools, to just make up the constant stuff that y'all make up, to have the president call for the execution of opposition lawmakers, to have the president claim that a civilian who was murdered was the victim of the disease of Trump derangement syndrome. And if it's not enough, well shit, for him to be a rapist, if it's not enough for him to be involved in the Epstein files, if it's not enough for him to murder people in the Caribbean, if it's not enough for him to designate a willfully taken substance as a WMD, to act as a premise to go to a war with a country that doesn't even export that substance to America, what are you guys doing? Where is your head at? What reality are you living in? I feel like you guys are playing a game that no one else is playing with you. When we talk about politics, we're worried about the actual outcomes of shit that happens to people on a daily basis. And you're over there going, well, can I at least make a feasible argument about this one? Not like one that a reasonable person would believe. Like in the instance of, oh god, the one that I keep hearing is when Trump was on the Howard Stern show. Is that what it's called? think. And he was bragging about walking in on naked women who were changing for pageant competitions. And he said, they're standing there with no clothes. And I have heard people on, like, Parker Get a Job or whatever, try to debate, well, he didn't say clothes. You don't know what he was gonna say. He didn't say clothes. He didn't say standing there with no clothes. You don't believe that, so what are you doing? You're playing a game. It's not a game. There aren't some points to win by seeing if you can come up with the best possible argument to defend your guy. What's up, Billy Billy? Oh, Billy Billy? Wow. I thought it was Billy Billy, and then I just actually read it. Billy Billy. I'm ranting right now, Billy Billy. Billy. I'm ranting right now to the void about how absolutely insane things have gotten. That the F drug, the F substance, has been declared to be a WMD, a weapon of mass destruction, as a pretense to go to war with Venezuela. Even though Venezuela doesn't export that substance to the United States, at least in any real capacity. And I've gotten to the point where I'm just like, what are you guys doing? People who support this. The number of things that have gone on is just nuts. Doesn't make any sense. Doesn't make any sense at all. What would be enough? And I've seriously started hearing people start saying, like, if Trump were found, there was enough proof to say that he had sexually abused children, they would still vote for him because of his policies. So we have gone off the deep end. Things are crazy. That's crazy. So yeah, that's what I've been ranting on. So now we're gonna go do some research. All right, research doc. We are doing the military owes allegiance to the Constitution, not to the president. Policy equals personal interests. What do you mean? At the point that you're supporting a rapist, like, let alone a child rapist, at the point you're supporting a rapist because they support your policy, something's very wrong with you. Like, that person's morals are moral policy, and you are supporting immoral policy. What was I doing? What was I doing? What was I doing? Okay. The oath of enlistment. Oh, wait, this is not correct. What am I doing, man? Didn't take my afternoon Adderall. Okay. That's not short enough? What? Believably, what's going on tonight? What's up with you today? Listening to my channel? I mean, what else today? What else is going on? I can tell you're here. I appreciate you being here. Shoot, I'm trying to remember my radicals. Man, I'm too out of practice. I can't recognize any of these radicals. Is the first one the field radical? Oath. Oath of enlistment. Oops. I blank do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, and that I will obey the orders of the President of the United States and the orders of the officers appointed over me according to the regulations and the Uniform Code of Military Justice, so help me God. That's interesting. I will support and defend the Constitution against all enemies, but I will also obey the orders of the President of the United States. But that comes Constitution because that stuck up on me. Constitution comes first in the oath. According to regulations. Well, regulations have to obey the Constitution, so it sounds like everything bends to the Constitution. The officer's oath. It's the army. Is it the same in each branch? My life direction is to enhance my self-worth. I am an immigrant. I do not have the right to vote. I am a neutral. I just came into contact with a neighbor who has participated in election activities. He talked about policy issues. Cool. Are you an immigrant to the US? So it's the same for all of them. Or here's the National Guard. Okay. Ah. Immigrant to Canada. Home of my first debate partner, the Nazi, self-described Nazi. What we got going on here? I'm lost. Officer's oath. I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to same, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. Wow, this doesn't even say that they will follow the orders of the president. Fascinating. Fascinating. What's next? Officers swear to support and defend the Constitution with no mention of obeying the president. Enlisted oath includes obey the orders of the president, but qualified by according to regulations and the Uniform Code of Military Justice, the UCMJ. The 10 USC 502. Okay. Didn't really tell me what I'm going to find there. So this is where it's provided in the law. Okay. Okay. USC 502A. And the oath of commissioned officers. Going to find at. This is not where I want to be. I'm gonna sneeze, excuse me. Okay. 5 USC 3331. IAB. USC 3331. Cool. Legal precedents. Key court-martial cases. U.S. v. Keenan established that service members must evaluate the legality of orders. That's fun. This is the first time we've looked at a court case, I think. U.S. v. Keenan. As a result of their conduct during combat reconnaissance patrol near the hamlet of Tri Ben, Republic of Vietnam, several persons were charged with murder. 2 charges of premeditated murder were laid against the accused. After 2 trials, he was convicted of premeditated murder of Nguyen Qua, an elderly Vietnamese male, and Nguyen Thai Co, his cousin, and sentenced to a dishonorable discharge and life imprisonment. The convening authority reduced the period of confinement to 25 years. Thereafter, a board of review... How long is this opinion? How long is this opinion? It's not that long. The convening authority reduced the period of confinement to 25 years. Thereafter, a board of review dismissed the charge relating to Wen Tai-ko and reassessed the sentence to reduce the period of confinement to 5 years. A government motion to reconsider dismissal of the charge and reassessment of the sentence was denied. Billy Blee, how has the transition been to Canada? Has it been what you expected it to be? The government motion to reconsider dismissal of the charge and reassessment of the sentence was denied. Under the provision of Article 67 UCMJ 10 USC 867, the Judge Advocate General of the Navy and the accused brought the case to this court for further review. We turn first to the 3 questions certified for review by the Judge Advocate General. This is the Court of Military Justice? Oh, okay. The third question asks whether the Board of Review was correct in summarily denying the motion for reconsideration. The Board of Review had written a lengthy opinion commenting on various assignments of error by the accused. Alright, I guess I'll keep reading. One of the assignments challenged the sufficiency of the evidence to establish that Wen Tai-ko was alive when the accused shot her. The government opposed the assignment of error on 2 grounds. First, it contended that the evidence established the victim was still alive when the accused shot her. And secondly, that in any case, the accused aided and abetted the patrol leader in completing the job of killing the victim by firing an automatic burst with his M14 at her, about 3 to 6 seconds after the leader had shot the victim in the head with a .45 caliber pistol. Oh my god. I hate criminal cases. Criminal cases suck to read. The Board of Review sustained the accused's contentions. Thereupon, the government moved for reconsideration, alleging that the Board of Review's opinion indicated it had failed to consider or to understand the law of aiding and abetting, and that as a matter of law, its opinion demands a finding of guilty of attempted murder. A divided Board of Review denied the motion without opinion. In U.S. v. Hurt, we noted that while it is preferable procedure for the Board of Review to indicate reasons for its decision, there is no mandatory rule that it do so. Whether and when an explanatory opinion is appropriate rests within the sound discretion of the judicial body. Huh. So I assume that Canada doesn't have birthright citizenship then. What's up, Maddie? What? Welcome to WMD Day. We finally found them. We finally found them. An exposition of reasons for denial of a second consideration of the case is generally less needful than on the initial decision. More often than not, therefore, an application for rehearing is denied without opinion. The fact that the denial is unaccompanied by a statement of reasons does not imply that no consideration, or inadequate attention, was accorded the substance of the application. Accordingly, we answer the third certified question in the affirmative. The 2 other certified questions are as follows. Was the Board of Review correct in dismissing the additional... Oh, we are not centered, are we? Let's fix that. Whoop. That's better. That's better. Women would be stripped of citizenship if they married a foreigner. Damn. That's no longer the case? When was that the case until? Was the Board of Review correct in dismissing the additional charge and its specification without considering the evidence of accused guilt as an aider and abettor? Was the Board of Review correct in dismissing the additional charge and its specification without considering the evidence of accused guilt of the lesser included offense of attempted murder? The language of the questions implies that the Board of Review did not in fact consider certain evidence relevant to the issues. The Board of Review's opinion is silent as to what alternatives of guilt and relevant evidence is considered. Its silence does not demonstrate error or oversight. U.S. v. Hurt. In apparent acknowledgement of the insignificance of the Board of Review's silence, the parties have construed the questions as bringing up for review the correctness of the Board of Review's action in exonerating the accused from all guilt in connection with the death of Nguyen Tai Co. Consideration of this question requires review of the pertinent evidence. Sometime between 8:30 and 9 a.m., September 22, 1966, a 10-man squad set out on a combat reconnaissance patrol in the Tri-Ben area. Corporal Stanley J. Luxco, regarded as a cool head under fire, was the squad leader. Other members of the squad were the accused, Corporal Paul F. Huber, Lance Corporal Nick Gonzalez, Lance Corporal Jerome W. Ketzenbach, Privates First Class Billy D. Eakins, David M. Moore, Roland A. Pietkowski. That's right. These guys are getting their names read on the internet 60 years later. Eat it. Oscar Martinez and hospitalman Donald L. Butner. According to the platoon commander, 2nd Lieutenant James V. Flynn, the accused was a very good Marine, whom he considered to be as good, if not better, than the rest of the platoon, which was composed of some very good troopers. The patrol passed through 2 small villages. At the first village, it was informed that Viet Cong were present across a rice paddy in the direction of the second village. A check of the immediate area led to discovery of several bundles of wood which had apparently been abandoned. These were regarded as evidence of Viet Cong presence. In the second village, because the Viet Cong were the ones who carried wood all the time, then someone will put forward the slogan of equality for all again. Expatriation Act of 1907. What do we got? Why are all these websites differently aligned? Section 3 provided for loss of citizenship by American women who married aliens. What? This is a US law. I thought we were talking about Canadian law. Oh, we were talking about... So you were saying we used to not offer birthright citizenship? Fair, I guess. Section 3 provided for loss of citizenship by American women. I mean, still awful that we did this in America. The act states that an American woman who marries an alien would lose her citizenship and take on her husband's nationality. In actuality, whether or not she could do this was dependent on the laws of the country to which her husband belonged. Oh, so we would end up with stateless people? If there was no similar law granting derivative citizenship to a married woman, she would then become stateless. Oh, cool. Cool. Okay. I have a personal question that I've never dared to tell my friends. My parents' monthly income is about $2,500. In Canada, their income has increased to $3,500. We are very satisfied. Why are there so many demonstrations? In Canada? So are you saying it was $2,500 in Japan and now it's $3,500? I assume that's in Canadian. This is monthly income. $1 Canadian is 73 cents of an American dollar. So 3,500 is worth less. So 3,500 times 0.73. Whoa, what's happening? Stop it. Stop. Clear. Okay. 3,500 times 0.73. $2,555 a month? Dude, that's 31K American. That's what I was making for a family of 3 before law school. That's rough, dude. That's rough. I don't know how you can be satisfied on 31K. When I was making 31K, it was like every single purchasing decision had to be so carefully made, such that like you had to think, can I afford to buy this thing that I reasonably need right now? Or do I have to suffer waiting to see if I can buy it later? And then you know that you can't afford an emergency if an emergency happens. You can afford 500 square feet, if even, depending on where you live. I don't know what things are like over there in terms of housing, but we could only rent in San Marcos, Texas. That's not even like a big city, but I mean, it is a college town, so maybe rent's higher there. I don't know. But when we got married, we could only rent a 500 square foot apartment that was infested with roaches. That used to be a drug dealer's home. And it was basically in an alley. They need to pay a lot of taxes. I mean, we basically learned to live with roaches because we had German roaches, and we kept being told if you have German roaches, you can't get rid of them. And it was like it was an alleyway of apartments all facing each other and on top of each other. It wasn't great. And I knew that I was like one car maintenance need or one hospital bill away from being financially ruined. So I don't know how you can be satisfied on that. But more importantly, you shouldn't have to be satisfied on that. And I think that is a reasonable position to take for demonstrations. Even if everybody was doing as well as I am, and the top 1% or 0.1% or 0.01% were continuing to just siphon everybody's money away, to take it little bit by little bit and accumulate it themselves. And because of that, we are missing out on governmental programs that we could be using to make everyone's lives better. Then I think demonstrations are called for. The thing is, we used to be tribal. And when we were tribal, we had a very small... Yeah. Especially in America. When we were tribal, we had a very small group of people that we were responsible for taking care of. And that didn't make life easy by any means. But it meant that the extent of our concerns didn't reach very far. But we spent every day, basically every day, making sure that we did something to make progress on collecting food for our tribe. But when we got to the point where we didn't have to do that anymore, we could plant seeds and live as a community. And then as a community, we could have people who focused on planting seeds and harvesting crops, and we had people who could do other jobs. And suddenly life became a lot better because we were able to rely on each other. When we band together, we can have more than we can have on our own. Stratification, but like stratification is just one example of it. When like we all individually have power. As a single person, your power doesn't reach very far. But when you group power together, I would go as far as to say that the effect of that power is exponential. 2 people's power is more than 1 person's power plus 1 person's power. 10 people's power is more than 2 people's power times 5. We started to become more sedentary, but the quality of life improved regardless. Health outcomes became better. We became able to become educated. Sure, we became more sedentary, and there are negatives to that, but there were massive amounts of positives that came with it. We were able to build walls. Over time, we were able to invent industry, and eventually that led to. I mean, this was already happening with tribes. It's like the often the strongest was able to just have power. Oh, what are you talking about? Okay. Are you saying that that's bad? Anyway, I was saying I was saying that might makes right when you are in small enough groups. Even if your tribe isn't that way, if somebody comes along who has that mentality, then suddenly your tribe's in a lot of trouble. So walls helped with that. And then we had kings, which very important at that point in the development of human civilization. Because kings unified people under them in a feudal sense, and that came with a whole package of rights. I mean, not necessarily rights, because the king decides what happens, but there are certain expectations that come with the king, and a lot of it is protection. Protection comes with having a king. But then the more collective power we had, the more we decided we didn't need kings, and then it became about the power of the people themselves. And the more personal power we accumulate over the centuries, the more better outcomes we have for people. So it doesn't matter that you reach a state where you are satisfied with... I know walls came after that, yeah. I'm talking about a long span of human history here. Right. So it doesn't matter if we reach a state of personal comfort. That doesn't necessarily mean that everyone in our situation is comfortable. And the fact that you're comfortable doesn't make other people being uncomfortable incorrect. And so what you have is... what am I looking for? You've got a state of human suffering. Even if you don't consider yourself to be suffering, other people are reasonable to consider themselves to be suffering if they struggle to get the things that they need. And I would say if they struggle to get things that other members of society can easily obtain. Because the people at the top of the pyramid aren't doing more work to gain that money. They aren't. It's not reasonable to believe that they are. So even if only in a relative sense these people are suffering, they are suffering. And so it's not wrong of them to be upset by their situation. And so what we're missing in that situation is that we have the power collectively to change it. And we should use that power. There is no reason to think that the people who have all of this money should retain it. There is no rational basis for that. If we collect that money to make it work for the common good, then once again, just as every other example of banding together to create common good, our outcomes will exponentially improve. The wealthy, in general, I won't say in every case, but in general, the wealthy didn't do anything to earn that level of status inequality to the common people. In fact, I would go as far as to say they have stolen so much of their well-being from the common people. Yeah, most of them were born to a high level, and most of them don't pay their fair share of taxes. And when you don't pay your fair share of taxes, that is theft, in my mind. You are stealing from the common good. And people who are wealthy are exponentially reliant on the power of the common people to obtain their wealth. So they should be paying exponentially more in taxes to enjoy the benefits of their wealth. Yep. Yep. And I say this as somebody who has a good income. I would be totally fine if I lowered my own income so that everybody could be lifted up and we could have a safe baseline for everyone to enjoy. Even if you study hard, you won't get the life you want, as long as other people are keeping it from you, and that is what the wealthy do. It is objectively true that hard work doesn't get you a fair share. That's right. Yeah. Plenty of people study hard for careers that just aren't valued by society, even when they should be. Teaching should be vastly more valued than it is now. We should be finding qualified teachers who know how to be successful in the classroom, who know how to create successful students, and we should be rewarding them massively so that others follow their example. We don't do that. And they can work as hard as they want, it won't fucking matter. And I'll say, it's impossible for those teachers to have the life they want. Because what they want is to be able to take care of themselves, to take care of a family, while doing what matters to them, which I would say I am thankful that these people have that matter to them. I am thankful that we have people who it is the most important thing to them that kids are learning from them, that kids are being inspired by them. If that is what drives somebody, that is an admirable person. And yet, for them to chase their dreams, they also have to embrace poverty. That is a monstrous society. I absolutely hate having to warn my daughter against her dreams. She has told me for her whole childhood that she wants to be a teacher, and I just have to sit there and be worried about it. And so I can't tell her, no, don't be a teacher. All I can say is, I want you to understand that if that's what you choose to chase, it is likely that you're going to have a hard time making enough money to take care of yourself. Yeah, at least then you get to study it, right? I mean, it's the same thing in law school. Like, I took so many constitutional law classes just because I love it, but there was never going to be a chance that I was going to spend my career in constitutional law. Never. Yeah, exactly. The end goal of con law is academia. And I would love to be in academia if I felt like I could take care of myself doing it. Right. Yeah, exactly. I mean, I studied under the guy who argues religious liberty law cases in front of the Supreme Court. And yeah, if I were him, I'm sure I might be making some good money. But as I said, he's the guy who argues religious liberty cases in front of the Supreme Court. There's not room for me there. There is no room when there's the guy. Sorry, we were reading U.S. v. Keenan. Learning about these very good Marines who are going to do some terrible things. We're learning about this because we're learning about the requirement of soldiers to assess the legality of orders they're given. The patrol passed through 2 small villages. At the first village, it was informed that Viet... Oh yeah, we learned about these several bundles of wood, which meant Viet Cong. Obviously. These were regarded as evidence of Viet Cong presence. In the second village, the patrol discovered a carved replica of a United States helicopter and a rubber tennis shoe. These too were considered as evidence of Viet Cong presence. On leaving the second village, Corporal Luxco decided to double back. Someone noticed hooches, or houses, across a paddy. Luxco halted the patrol. He divided it into 2 elements. One group, consisting of 6 men, was ordered to stay on the trail. The other element, consisting of Luxco, the accused Eakins, and more, formed a skirmish line and moved into the area of the houses. What occurred there led to the filing of the charge of premeditated murder of Wen Tai Ko against the accused, who allegedly acted in conjunction with Corporal Luxco. Moore and Eakins testified as government witnesses. According to Moore's testimony, he, Luxco, and the accused approached a house from one side, while Eakins moved eastwardly in the brush behind it. Although there is no direct testimony as to the accused's immediate actions, apparently he entered the house with Luxco while Moore checked an outside area. Finding nothing, Moore returned to the house. Luxco came out and they talked for a minute. Luxco then occupied himself with trying to move a calf into a cow pen. What? Suddenly, Moore became aware of a woman behind him at a haystack. According to him, he and Luxco saw the woman. Luxco pulled out his .45 caliber pistol and started to play with it. Oh my god, I don't want to read that. Oh, okay. I hate criminal law cases. I said this earlier, I hate criminal law cases. They're always horrible to read. He heard a shot from a .45 pistol. Eakins testified he saw Corporal Luxco engaged in conversation with the woman. I learned to turn my feelings off in criminal law class, and it's been a while since I've had to read a criminal law case. There's a case that we read in criminal law about there was a casino where some underage kids were in there, and I don't know the story behind this, but I think I remember what happened. It was one of the underage boys was wondering where his underage friend was. And then he went to the men's room and discovered that his friend had taken an even younger girl into that stall and was doing things to her, and he just left. And I remember reading that case and just going, I wish that kid had gotten the death penalty. I don't agree with that now, but I remember just being so sick to my stomach reading that. Sometimes I just hate human beings very much. That case will never leave me. Eakins testified he saw Lusko still at the same spot at which he had left him. As he approached, Lusko fired at the woman who seemed to be squatting by the haystack. The accused also approached Lusko and spoke to him. That's a very normal reaction. Eakins testified the accused asked Lusko if he had shot the woman, and Lusko replied that he had. Moore and Eakins testified that the accused asked a second question. Moore maintained the accused asked, "Should I finish her off?" And Eakins testified that PFC Keenan asked Corporal Lusko if he wanted him, PFC Keenan, to finish her off. The accused denied he made any such statement. All agree, however, that Lusko said nothing, but aimed his pistol at the woman and fired a third time. They believed she was dead. The accused's direct involvement in the incident occurred in the interval of 3 to 6 seconds that followed. As the woman's body began to fall forward, Corporal Lusko said, "Finish her off." The accused, who testified he was ready to fact a firing situation when he left the house, fired an automatic burst. I almost feel like I'm reading too much violent content for this, but I'm reading a judicial opinion. So that feels... Man, I don't know. Yeah, I bet that was something. Moore estimated the interval was about 4 seconds, and the accused thought it was 5 or 6 seconds. The accused maintained that he did not think the woman was alive when he fired, and Moore stated that the accused told him later he thought the woman was dead after Lusko shot her, and he did not know why he had fired at her. Moore, Eakins, and the accused started to leave the area, but were called back by Corporal Lusko to help him do something with the body. Lusko pulled some hay from the haystack, put it across the woman's body, and set it afire with a heat tab provided by Moore. The four stood there a few minutes, then left. See, this is one of many problems with war, is that some people delight in it. Some people have been waiting their whole lives to have the excuse to do things that war allows them opportunity to do. Doesn't allow them legally to do, but allows them opportunity to do with the hopes that they can get away with it. It is a breeding grounds for cruelty. Yeah, they're waiting for the opportunity to see what a gun can really do. What a gun was really designed for. Lieutenant Commander John L. Reed, a surgeon, testified as government expert witness. In his opinion, death was inevitable for a person receiving the wound from a .45 caliber pistol like that of the victim, but he maintained that respiration and heartbeat would be present for a period of 4 or 5 seconds thereafter, so that for death certificate purposes, the wounded person would be dying as opposed to being dead. He admitted that in terms of his definition of death, even a headless body would be alive in theory and fact for several moments after decapitation. He also admitted that, in the absence of seeing the body, it was difficult to say when death actually occurred. He had never examined the body of Lin Tai Co and had never examined a person with a 45 bullet wound over the right eye. The Board of Review indicated it was not convinced beyond a reasonable doubt that the victim was alive at the time the accused fired at her. On the basis of that finding, it absolved the accused of all criminal responsibility in the death of Lin Tai Co. Appellate Government Counsel contend the Board of Review's finding of fact does not automatically render the evidence insufficient to affirm a finding of guilty, either on the ground that the accused aided and abetted Corporal Luxco by encouraging him to complete the crime, or on the ground that he committed the lesser included offense of attempted murder. Although, as noted earlier, the Board of Review did not set out its reasoning, it was manifestly well aware of the government's contentions as set out in its brief on the original hearing and in the application for rehearing. By denying reconsideration, the Board of Review patently rejected any view of the evidence that required it, as a fact-finding tribunal, to assess some degree of culpability. It would appear, therefore, that rather than disregarding the evidence relied upon by the government to support the alternatives of guilt suggested by it, the Board of Review concluded that this evidence did not establish any degree of guilt beyond a reasonable doubt. On this record, the Board of Review was not wrong as a matter of law. As to guilt as an aider and abetter, the Board of Review could reasonably add note 3... What? Huh? What? All the evidence is to the effect that Luxco was in the process of... I'll read it as it's stated. As to guilt as an aider and abetter, the Board of Review could reasonably add note 3 he contention that by merely asking Luxco whether he should finish off the woman, he associated himself with Luxco's purpose and encouraged Luxco to fire the third shot. Something weird happened right here. All the evidence is to the effect that Luxco was in the process of recocking his pistol when the question was asked, that he said nothing to the accused in response to the question, but raised his weapon, took careful aim, and fired. Luxco fired the first shot at the woman when the accused was in the house with Eakins. He fired a second shot in an interval just about time enough to recock his weapon, and he fired the third and final shot in the same interval required to recock the pistol. The inexorable quality of his actions and his total disregard of the accused and the others indicate that he did not look to anyone for encouragement or assistance. In these circumstances, the Board of Review could have determined that the accused's question was only a tentative offer to help, which was rejected by Luxco. It could, therefore, have properly concluded that the accused did not aid or abet Luxco in his deadly assault upon the woman. So far as attempted murder is concerned, military law has tended toward the advanced and modern position that holds one accountable for conduct which would constitute a crime if the facts were as he believed them to be. Here the accused expressly testified that he believed the woman was dead, and the Board of Review specifically refused to find that she was still alive when the accused fired at her. Moore and Eakins also testified that they believed the victim was dead before the accused fired. The Board of Review could therefore reasonably conclude that the accused knew he was firing at a corpse. We haven't yet gotten to the point of this case that was the reason that I started reading it for. Okay, bye. Have fun being away from keyboard, whatever you're doing. Our decision as to the certified questions makes it unnecessary to consider several of the accused's assignments of error, including a contention that the second trial for Lin Tai Co's death was illegal because, at the first trial, the law officer denied the government leave to amend the specification to change the victim's name from Lin Tai Co to Lin Tai Kung to Lin Tai Co, and instead of dismissing the charge because of the variance, granted a defense motion for a finding of not guilty, which was sustained by the court-martial after one member had objected to the law officer's ruling. Can we get to the point? Corporal Luxco, the accused, Moore, and Eakins left the area where the woman had been killed to rejoin the six-man element that had remained on the trail. As they came in sight of the group, one of them yelled out, "There's a man coming!" The man was over in the brush to the south of Luxco's element. Corporal Huber called to Luxco's element to check the man's identification, and Luxco directed Moore and Eakins to check out the man's ID. Moore called to the man, and he and Eakins walked toward him as he approached them. At the point where they met, Luxco and the accused were about 15 feet away, standing either next to each other or about 4 or 5 feet apart. Eakins examined the man's identification card and then handed it to Moore, who also examined it. Moore recalled that he had seen the man sometime earlier on the trail and had checked his identification. The man's identification card appeared to be in order. He did not seem to be armed, and neither Moore nor Eakins considered his conduct suspicious. Moore returned the identification card to the man, and Eakins called out to Luxco, "He's alright." Luxco instructed them to check out the area in back of the man. Eakins started back at an angle, and Moore walked toward the rest of the patrol. What happened next is described piecemeal by 4 government witnesses. Eakins glanced back and saw the man show his identification card to Luxco. He turned and started toward the rest of the squad. Huber also saw Luxco checking the man. The accused was about 4 to 5 feet to the rear of Luxco. Huber looked away. Lance Corporal Gonzalez saw the man walking away from Luxco. When they were about 5 feet apart, Luxco raised his .45 and Gonzalez heard a round go off. The shot caused Moore, Eakins, and Huber to turn in Luxco's direction. Yep, this is that sadistic power fantasy you were just talking about. Dude killed somebody and suddenly he couldn't get enough of it. Moore testified that when he looked facing this area where Luxco was, he saw the man running, and Luxco had his arm out with his .45 pistol pointing toward the man. Moore heard 2 more .45 shots from Luxco's vicinity, then heard Luxco shout, "Fire, damn it, fire!" Moore opened up. According to him, the accused fired a burst from the hip. Moore further testified that the man ran up an embankment and collapsed. Moore maintained that he fired at the man in response to Luxco's order, and because when he arrived in Vietnam, he had been told by experienced combat personnel that if a man runs, shoot him. Wow. Eakins testified that when he turned, he saw the man about 15 feet from Luxco, who had his .45 in hand. Eakins saw Luxco take a well-aimed shot at this old man, who slumped to his knees, recovered, and started toward the bushes. As he watched, he heard an automatic burst from the direction of Luxco and the accused. Luxco faced him and hollered, "Fire, damn it, fire." He raised his rifle and fired. He testified he fired because he had been trained to obey orders without asking any questions. And he saw Luxco had the .45 pointed at him. And he thought Luxco would use it if he did not obey. Gonzalez, who was with the six-man element, also saw Luxco raise his pistol, and he heard the round go off. Okay, enough of that. Huber did not fire because he didn't see any reason why he should. The 2 elements of the squad then rejoined. According to Eakins, Pietkowski and Ketzenbach asked Luxco if they could look at the man's body. He gave them permission to do so. Both men headed back in the direction of where the man was. Shortly afterward, Pietkowski called out that the man was blinking his eyes and he's moving his mouth. Huber tested, "No, I don't want to, oh my god." Pietkowski then fired. Pietkowski and Ketzenbach rejoined the squad, and it returned to the company command post with instructions from Luxco to say nothing about the incident. The accused was charged with premeditated murder of Nguyen Qua in conjunction with Luxco and Pietkowski. At his first trial, the question of accused guilt or innocence of this charge was not submitted to the court-martial. Instead, after some discussion about the evidence pertaining to the assault on the woman, the law officer concluded that an instruction to the court members to disregard the evidence as to the dismissed charge would be useless because they probably could not erase this evidence from their minds. In his opinion, there was an ineluctable carryover because the offenses occurred in a short period of time. Over defense counsel's objection, he declared a mistrial. Thereafter, the charge was referred to trial a second time, together with a new specification alleging the murder of Nguyen Tai Co. The accused moved to dismiss both charges on the ground of former jeopardy. The motion was denied, and the ruling was affirmed by the Board of Review. A mistrial can be declared by the law officer when required by manifest necessity. Various situations fall within the rule. Among them is the condition created by receipt of information that another serious crime was probably committed by the accused. If there is reasonable likelihood that the court members cannot, or probably will not, disregard this evidence, despite instructions to do so, the law officer may properly declare a mistrial. The ruling involves a degree of discretion, and an appellate court will not overrule it unless there was a clear abuse of that discretion. Although the accused did not testify as to the assault on Nguyen Qua, one of the principal arguments of counsel dealt with whether the accused, like Moore, Eakins, and Gonzalez, merely responded to Corporal Luxco's order to fire. Appellate defense counsel present several assignments of error dealing with the matter. We consider first the contention that the evidence is insufficient to show that Luxco's order to fire at Nguyen Qua was illegal. Okay, I'm just gonna find the point of this. I can't keep reading a case this way. We need to find the legal rule. As of the first part, the instructions are not for... Okay, rather they correctly apprise the court members that a homicide committed in obedience to a lawful order is justified, but one in execution of a patently illegal order is not. As to the second part of the argument regarding the court's determination of the accused guilt or innocence, we cannot follow appellate defense counsel to their conclusion that the instructions deleted an important element of the crime of murder based on the theory of aider and abetter. In context, the challenged instruction was a correct statement that the trial concerned this particular accused, and the court's duty was to determine, on the basis of the evidence before it, this accused guilt or innocence, not that of any other member of the patrol, several of whom had admitted firing at the victim. Oh, okay, that's very abrupt. Okay, the verdict in Pietkowski's case is not inconsistent with the findings of guilty against this accused. Even from evidence in this record, it is apparent that Pietkowski acted separately at a different time from the accused. Determination of the criminality of the accused's conduct, therefore, in no way depends upon or requires reference to Pietkowski's conduct. Oh, hi. Reading a tribunal case about some really terrible people in the Vietnam War. In this regard, the situation is similar to the accused's involvement in the death of Nguyen Thi Co. As noted earlier, the accused testified that he believed Nguyen Thi Co was dead when he fired at her, but Pietkowski apparently believed that Nguyen Qua was alive when he fired at him, as evidenced by his statement that the man was blinking his eyes and he's moving his mouth. The accused's belief led the Board of Review to dismiss the murder charge against him. Pietkowski's belief that the victim was still alive justified his conviction for attempted murder. Corporal Luke Sko's acquittal of complicity in connection with the death of Nguyen Qua is viewed by appellate defense counsel as demonstrating that the court-martial that tried Luke Sko obviously felt the killing of the man was legal. However, there is evidence in this case which suggests that Luke Sko's acquittal of murder was probably not predicated upon the nature of his order, but upon the extent to and the circumstances under which he participated in Nguyen Qua's death. Gonzalez's testimony indicates Luke Sko's shots inflicted no fatal injury, while those of this accused at least conjoined to end the victim's life. Probable differences in the evidence and the inferences drawn therefrom make it apparent that Luke Sko's acquittal does not require reversal of the findings of guilty against this accused. Where... Oh my god, what did I read all this for? Stop. How's it going, Light Spectre? What you up to? Have you finished blueprints yet? I know you told me that the concept of finishing blueprints is a hard one to really confirm. Am I reading a different part of US v. Keenan? Apparently I'm reading a different part of the proceedings of United States v. Keenan. Okay. 18 CMA 108. 18 CMA 108. I don't see that language. Stop it. Okay, it's in the notes section. During the pendency of this appeal, the Secretary of the Navy mitigated the sentence by changing the dishonorable discharge to a bad conduct discharge. Hell yeah. Wait. What? No. That's less? I've never heard of a bad conduct discharge. Finished with the idea of launching the blueprints application. Currently updating firmware on my new smartwatch. Nice. Smartwatches are fun. Now, the evidence in this case consists of the sworn testimony of the witnesses, all exhibits which have been received in evidence, and all facts which have been admitted or stipulated, and all applicable inferences stated in these instructions. Any evidence as to which an objection was sustained by the law officer, and any evidence ordered disregarded by the law officer, must be entirely disregarded. You are to consider only the evidence in the case, but in your consideration of the evidence, you are not limited to the bald statements of the witnesses. On the contrary, you are permitted to draw from facts which you find have been proved and such inferences as seem justified in light of your experience. An inference is a deduction or conclusion which reason and common sense lead the court to draw from the facts which have been proved. Now, there is nothing peculiarly different in the way a court is to consider the proof in a criminal case from which all reasonable persons treat any question, depending on the evidence presented to them. You are expected to use your good sense and consider... We've had evidence in the case regarding orders by a superior and the legality thereof. The general rule is that the acts of a subordinate, done in good faith and in compliance with a supposed duty or order, are justifiable. This justification does not exist, however, when these acts are manifestly beyond the scope of his authority, or the order was of such a nature that a man of ordinary sense and understanding would know it to be illegal. Thus, the acts of a Marine done in good faith and without malice, in the compliance with the orders of a superior, are justifiable, unless such acts are manifestly beyond the scope of his authority, and such that a man of ordinary sense and understanding would know them to be illegal. Wow, thank you for the duplicative language. Therefore, if you find beyond a reasonable doubt that the accused, under the circumstances of his age and military experience, could not have honestly believed the order issued by his squad leader to be illegal under the laws and usages of war, then the killing of the alleged victim was without justification. A Marine is a reasoning agent who is under a duty to exercise judgment in obeying orders to the extent that where such orders are manifestly beyond the scope of the authority of the one issuing the order, and are palpably illegal upon their face, then the act of obedience to such orders will not justify acts pursuant to such illegal orders. Okay. You got a Pebble, one of the relaunch units, but it's basically the same thing as the old one. I've never heard of a Pebble before. Sorry. Call me clueless. Because I tend to be. I should get outside. Okay. I mean, I've never really followed Kickstarters. Oh, I jumped to USV Keenan without looking at the UCMJ. I should really look at the UCMJ. I've been playing Clair Obscur. Have you played Clair Obscur yet? Not into it. Did you start it and go, eh? Or did you look at it and go, eh? What's up, Maddie? Not a fan of turn-based combat? Well, then I'll have something to talk to Addie about on Wednesday. I think I just beat a super boss without realizing it was a super boss. Clair Obscur is weird in that way. Because if you can time all of your parries correctly, then you never get hit by anything. So you can just fight something that's way too powerful for you. Because when I beat this creature, I got like an ability called Cheater that lets you always go twice, and I was like, wait, this seems like an end game type of thing that I'm supposed to get only once I've like conquered things that are way beyond my ability, and I don't think I'm that far in the game. Whoops. I can't just shoot baddies in the head. I need the narrative. I need the narrative. And unfortunately, shooting baddies in the head doesn't usually come with a worthwhile narrative. Okay, what am I doing? Borderlands 2 was great. You know what I freaking love? Let's see. Man, I could just vibe to this music all day. Ooh, this one hit me hard. When I heard it, I just had to stop. This game may have been one of the highlights of my last marriage. I can just focus on the game. Yeah. Played this game with my ex-wife, and boy, it was one of the better memories. What? Any person subject to this chapter who willfully disobeys a lawful command. Okay. It's Article 90. Okay. Oof. Where'd all the crazies go? We've had a couple days now without anybody coming in and challenging us on liberal, ridiculous, what was it, liberal propaganda? Can't wait until I've got more momentum going. I can just rely, like, bigger people will reliably come in. That's why I gotta keep doing this every day. By the way, this is the 7.5-hour extended version, so I don't know if I'm going to realize when it's time to stop listening to it. What are we going to? 91, 92. Okay, so all we're relying on in the UCMJ is that it requires you to obey lawful orders. Does the UCMJ not say anything about unlawful orders? Really? I mean, that, I guess legally that works. If it says you're punished when you disobey a lawful order, but it doesn't say anything as to the opposite of that, I guess you can assume that you won't be punished for disobeying an unlawful order. But I prefer my law to be more direct than that, especially if I'm going to hinge my expectations of service members' conduct on it. I would like the UCMJ, you know, as a civilian, I would like it if the UCMJ said you won't be punished if, you know, you disobey an unlawful order. If not, you perceive the order to be unlawful. Would be nice if our service members could determine for themselves if it seemed to, like, maybe if you said reasonably interpreted an order to be unlawful. Then they wouldn't have to they wouldn't have to go, well, I guess this will be tried, and if they find the order was lawful, and even if I thought it was unlawful, I'm still going to be punished. Then at least you could hang your hat on, well, I think I reasonably thought that it was unlawful, even if it turned out to be a lawful order. If I reasonably thought that it wasn't, then I cannot act. I can disobey the order. I think the UCMJ should probably be phrased that way or some way similar. Let's see, would the AI tell me otherwise? Okay, I have decided this is enough of this music. As much as I love that song. Knew the orders to be unlawful, or a person of ordinary sense and understanding would have known the orders to be unlawful. Yeah, as a civilian, I don't like that. That was from Borderlands 2. It was the badass crater of badassitude. So the is it the UCMJ? Because this seems to be citing a different rules for court-martial. So under the rules for court-martial, you won't be punished if you knew the orders to be unlawful, or if a person of ordinary sense and understanding would have known the orders to be unlawful, which I, as a civilian, don't think is a good test. I would prefer if a service member were allowed to disobey an order because they reasonably perceived the order to be unlawful, even if it turned out not to be. I'm not sure about that, Light Spectre. Mistake of law defense argues someone didn't have criminal intent because they misunderstood the law, but it's rarely successful as ignorance of the law. Yeah, I was about to say, I feel like these are overlapping concepts. It can work if a defendant reasonably relied on an official misstatement of the law. Yeah. That's the oddity that I was remembering. If a person you would expect to get the understanding of law from misstates the law to you, then it is a reasonable defense. Or if the crime requires specific knowledge of illegality. The dictates of a person's conscience, religion, or personal philosophy cannot justify or excuse the disobedience of an otherwise lawful order. Well, that's not the argument. From legal experts, a subordinate who disobeys based on that belief takes immense risk of conviction by court-martial unless he or she can prove the order was truly illegal. Yeah, exactly. That's the problem. That is my problem. The only way to find out whether an order is legal or illegal is to obey or refuse to obey and see what is decided after the fact by a military court. You obey or disobey any order at your peril. Cool. Systematically punishes constitutional caution. I don't think the system is designed to make soldiers hesitate before refusing. Wait. Yes. Okay. No. It is designed to make them hesitate before refusing, but it is not designed to make them hesitate before obeying. So wait, is the AI now telling me that in text the military's oath is to the Constitution, but in practice it's to the president or to commanding officers? I mean, I think that's true, but don't feel like the AI is really supporting the argument here. It's kind of supporting the alternative argument. Which, I mean, saying that the argument is incorrect in practice doesn't really say anything about whether like legally it's correct. Well, that doesn't really help the argument. Okay, in that sense, it is. It is evidence that we need constitutional reform or legal reform. I agree. Yes, we need legal reform on disobedience of unlawful orders. I could make that a debate slide. My lie, my my Marine coworker was telling me about my lie. I'd never studied on it. Superior orders defense rejected for manifestly illegal orders. I think I can just copy that verbatim. Oh, US v. Keenan. What year was that? 1969. Nice. Nuremberg principles. Manifestly illegal standard. Yep. Constitutional framework. Posse Comitatus Act. Limits on using military for domestic law enforcement. I mean, the Posse Comitatus Act is an argument that the Constitution is above the president in terms of the allegiance of our military. I have an Article 2 where I have the right to do whatever I want as president. That, you want me to spend multiple days researching this? No chance, no shot. What the hell? No, I'm done. I'm done, AI. What the hell? That's a good point. That's a good point. I think I'm going to wrap up here in just a second, guys. Oh, right. Meant to add that. Ah. Rules of courts martial. Rules of courts martial 916D. Sure, I'll use that language. Okay, that's our third of what 53 debate topics. Woo! What do we got as our next one? Trump unlawfully defunded agencies and programs created by Congress. I mean, that's just power of the purse. But all right, I'm sure we can get some court cases too. But that'll do it for now, guys. It's a slow night. It's a slow night, and when it's a slow night, I'm willing to recognize it's a slow night and just give myself an opportunity to take some rest. All right. Well, Light Spectre, Maddie, thank you for being here. And thank you, Billy Blee, if you're still here, for being here. I mean, I think I can check, right? Yeah, forget it. For whoever's here, thank you for being here. Wish me luck on a second date tomorrow night. I'm no nothing attorney. I know nothing, so you can too, because it's only a it's only in embracing that we know nothing that we can actually learn anything, and that's what we're here to do. Heart, heart. Yo, look, I'm like the kids. This is so old. Now it's this. Um, and as always, I'm proud of you. I don't need to know you for that to be true, but for those of you in chat that I do know, it's also true. You deserve to hear it because life is hard. It's always been hard. and it always will be hard. But the way you face every single day, the way you do, is remarkable. So stay remarkable, and I'll see you next time. And that'll be tomorrow night. And hopefully I'll be able to report back something good. Man, Billy Blee, you've stayed with us the whole time. I appreciate that. Thank you. I saw you've been gone, like you've been quiet for a while, so I thought you may have left. I appreciate lurkers. Thank you. And that's 3 people. Did y'all make that? Did y'all make the average 3 or more for the stream? Did y'all make the average 3 or more for the stream? I guess it won't count until I turn the stream off. We'll find out. But thank you guys. Thank you. Y'all have a good night. See you tomorrow.